For those of you facing a violation of probation on a new drug allegation, right? I've got this interesting case that I really like, Martoral v. State. And Martoral was on 3 years of probation and was accused of violating the probation by possessing some more drugs. And he got 10 years prison on the violation. He didn't do any time initially, just got 3 years probation, but upon violation got a decade in prison. Here's how it went down. Martoral and a passenger are in a pickup truck when the cops unrelatedly come to the scene to investigate some drug shenanigans. And they're passing up the pickup truck that Martoral's in the driver's seat, and there's a passenger too. And they notice right there in the open on top of the center console that there are some drugs. And they immediately take them both down and charge them with possession of these drugs. Now, Martoral was found guilty of violating his probation based on this, and they gave him 10 years prison. But he appealed the decision, and he appealed it because in order to prove possession in the state of Florida, folks, you got to have knowledge and you got to have dominion and control over the drugs. Now, I will say this. If you have drugs in plain view, they've got knowledge. You are presumed to know the drugs are there if everybody on earth can see them. Okay, they had knowledge on Martoral, but did they have dominion and control? How can you show that Martoral in the driver's seat had dominion and control over those drugs versus the dude that's in the passenger seat, right? Florida law requires something more than mere proximity to the drug. Got to have more than, oh yeah, well you were close to the drugs. So what? The passenger was close to the drugs too. That ain't gonna cut it. Even if Martoral was slightly closer to the drugs, you don't get dominion and control just because the drugs were shifted a couple inches towards the driver's seat. That is not gonna get you possession. The court, throughout the violation, throughout the 10 years prison, said, hell no, you guys have not proven a possession charge. And not only that, but you didn't even prove possession to a lighter standard. Remember, folks, violations of probation are a pretty light standard, the preponderance of the court proof. It's not beyond a reasonable doubt like an actual initial criminal charge. It's a much lower standard. Just, can we convince the judge that this guy possessed him or not? And the appellate court said, no. The state did not present enough proof. We hold that even under the lesser burden, the evidence at this VOP hearing was insufficient to establish that he had dominion and control over the drugs. Nothing in the evidence before the trial court tied the drugs to Martoral as opposed to the passenger. Indeed, the evidence did not establish that the pickup truck was owned or even regularly driven by Martoral. They had nothing. Oh, you're in the driver's seat. You must be guilty of whatever you can see in the center console. No, you must not be guilty. You need more than that. The court threw out the 10 years prison. This is a good decision. And for those of you facing violations of probation, you do need an attorney that is going to dig a little deeper. Don't just presume that they win, right? So if you get a violation in Central Florida, I hope that you'll give our office a call. Thanks for watching.